Good evening, Crime Talk aficionados. This is ScottReisch, and we are coming to you from my residence here in Denver, Colorado. And it is a little late in the evening. However, sometimes find this is a good time to go live, as don't have all the issues going on throughout the day and interruptions, and can actually sit and speak to you all. Now, first, Chris Watts. Many people have seen a lot of the videos out there, and what I've come to find out is not everyone has seen the actual discovery, the police reports and paperwork that are produced in the investigation. You can find them out there, but we got them directly from the district attorney, and we had them, and I was thinking to myself, why don't we just put those out there so that everybody can see them? The only thing that we have that is not uploaded are the videos, as well as the autopsy reports. And I'm kind of debating whether I should do that, just given the nature of those autopsy reports. I'll probably continue to think about that a little further. But if you wanted to see all of the discovery in the case, I think it's some 1,600 pages that had been turned over basically by the time that Chris Watts had pled guilty. And those 1,600 pages provide really some nice summary of the investigation up to the time that Chris Watts was arrested and up to the time where he pled guilty. And as you can see when you read those reports, the police really had no other suspects other than Chris Watts. So if you want to see those documents, you have to go to my webpage, ScottReisch.com. And on that page, there's a section that says Chris Watts documents, and it's broken into, I think, 4 parts is what we had to load them into, as well as we broke them down for the emails and the text messages that Nicole Kessinger had actually written. And if you've been on my page before, there was a video that we did back in December and basically said, is this the email that started it all? And I think we were really the ones that brought that out, and we showed it because a lot of people, I think a couple people talked about it, but nobody actually showed the emails. So all those are there, as well as the text messages that were turned over and produced by the police from Nicole Kessinger's phone, and also her friends, whereby she talks about her relationship with Chris Watts. There is a link down in the informational section of these videos that that has the link to ScottReisch.com. Now, first of all, I appreciate everyone who tunes in and watches the program here on Crime Talk. But if you're new to the channel, please like the button. Please hit subscribe. Hit the little bell if you want to have notifications. And like I said, so there's a couple of things we'd like to talk about this evening. First, the Watts case. If anyone has any questions, we can talk about that, or comments. We can discuss that. And then I'd also like to talk about the Syed case in New Jersey, whereby it was the serial podcast of Adan Syed. And in that particular case, that was a serial that had been done by basically National Public Radio. They produced it, and it really questioned whether Mr. Syed was truly the one that was guilty. Mr. Syed was granted a new trial some 20 years later, based upon, frankly, a lot of the publicity that had taken place around that case. And for those who are not familiar with it, Mr. Adan Syed was convicted in 1999 for the murder of Han Min Lee. And they were high school sweethearts. And she was found dead, and he was basically the last one with her, and he was ultimately prosecuted and ultimately convicted. And what happened after that is he went to prison, obviously, but he had a group of supporters. And some of his supporters, one of the friends, ultimately went to law school and had really tried to develop new evidence in this particular case. And it wasn't until the podcast came about whereby these basically more attorneys got involved. There was money raised for his defense, and ultimately he was granted a new trial. And then just last week, the appellate courts decided that he wasn't entitled to any type of new trial, and so he will have to appeal yet again. But the interesting story that broke as of this week was that the district attorney had requested that many items from the crime scene be tested for DNA. Back in 1999, DNA was really just kind of developing, and it wasn't to the point where it is today. And frankly, it was somewhat reliable. I remember one of the first cases that I had, let's see, now it was 1996, I guess. I was still in the military. DNA had just come about, and everyone was still questioning the reliability of it. So in 1999, a little bit of testing was done, but nothing conclusive. The district attorney in this particular case since managed to test, I believe, some 20 items, including the T-shirt, the necklace, under the fingernails, looking for any type of DNA. Well, Mr. Syed's DNA did not come back as a match on any of the items that were in fact tested. Only that of the victim, Miss Lee, and an unidentified female came back. And so that was kind of interesting fact. And apparently it's been known to both the prosecution and the defense for a while, but it's only come basically out as a result of some newspapers trying to seek release of the information. The items that were tested were necklace, T-shirt, jacket, and rope that was found at the scene. Now, a lot of people would say, well, there's no DNA there, so he must be not guilty of the crime. Well, not necessarily. It just means that his DNA is not there. And obviously to his supporters, they want to use that to say, if there was a struggle, as alleged, as the prosecution's theory proposes, that if there was a struggle involved, that DNA would have been transferred to some of these items. And the fact that it isn't, the district attorney says it doesn't prove anything. It just simply says his DNA is not there. It doesn't mean that he didn't kill Miss Lee. And so, although the district court, who I think probably had a lot of pressure from kind of the public and everybody to say, hey, give the guy a new trial, the appellate courts just recently reversed that decision. And so the question is now, does he appeal? If the state Supreme Court doesn't grant him a new trial, then his next remedy is simply to go to the federal courts and file what they call a habeas petition. But the interesting thing about habeas petition, if anybody's ever done those, I've done one or two, but you have to exhaust all of your remedies in the state court to do that. And then it's really kind of tricky at one point. So you go to trial, you appeal, and then after that, usually if somebody's convicted of murder, then the defendant will file what they refer to as a post-conviction relief, whereby they say that their attorney, whether at the trial level or the appellate level, were ineffective. And as a trial attorney that does homicide cases and any kind of serious case, you're always thinking, what do I need to do so that I protect myself? Not only you want to do everything you can for your client, but you have to be thinking, all right, this guy's going to be in prison for the rest of his life, and he's going to be writing petitions for the next 20 years. What should I be doing so that as an attorney, I don't get accused of being ineffective? Now, in some cases, you have clients that you really think didn't do it, and you think, well, would I say I didn't do anything? And I've always been of the position that if I did something wrong, actually did something wrong, or I failed to do something, maybe my strategy wasn't correct, that's simply not enough to get a new trial. But frankly, maybe there was an expert that I should have done, should have hired, should have consulted with. Those types of issues really make you think, what do I do? Thanks you, Janae, for the super chat. Appreciate that. If anyone would like to have their comments highlighted, they can use the super chat, and I'm not asking for you to do that. You don't have to do that. I'm not looking to raise money of any kind here whatsoever, but it does help when they go by so that they're highlighted. So back to the post-conviction relief claim. So the defendant, he gets convicted, he appeals, and then you go after that to post-conviction relief. New attorney comes on and he says, hey, explain to me why you did this. Explain to me why you didn't hire an attorney. Why you didn't hire another attorney. Why you didn't hire an expert. Why didn't you hire a mitigation expert? Why did you not hire a psychiatrist to comp this person? Maybe you didn't do enough mitigation work. Did you hire a mitigation specialist? And a mitigation specialist is someone that literally goes around, collects all the records, medical records, school records, any police involvement that a defendant has ever had, to see if maybe he got his head whacked, maybe he had a traumatic brain injury that was never treated, concussions, something along those lines, so that you know that you've done everything that you possibly could for that defendant. Because I assure you, if somebody goes to prison for a long time, a lengthy sentence, they may say, hey, Scott, you were a great attorney. You're the nicest guy in the world. You're the first person in my life that has ever fought for me. But nothing personal, but I'd really like to go home and get out of prison someday, so I'm going to file a post-conviction relief matter. And so there's two routes that people take on that. The first one is they file it with the court, and then the court will decide whether an attorney is appointed or whether if they have their own attorney, they go through that. Now, if you've ever done 35C work or post-conviction relief work, it's always interesting because I've had people that have not hired me because they said we were too expensive, and then they go through the appellate process and they say, well, that's too expensive for us as well. And then they come back when it's all said and done and they say, okay, now we have all the money. And it is the most expensive part of the process in a post-conviction relief, because literally the post-conviction attorney, thank you, Jojo, I appreciate that super chat, but that is the most expensive part because the post-conviction attorney has to go get all the discovery, get all the attorney's files, get the discovery from the district attorney, and literally start from scratch and go through and try to figure out what, if anything, could have been done differently. And it's the test is, the legal standard is not just that it should have been done differently, but it also has to show that, one, the attorney was ineffective, which is a very tough standard to overcome, as there is a test set out by the Supreme Court. And it's called the Strickland test, and it's United States v. Strickland. And in that particular case, it basically lays out the parameters of what is an effective attorney. And it's not just because you lost, because frankly, defense attorneys lose trials all the time. In theory, the defense is supposed to lose because the prosecution shouldn't bring a case unless they believe that they can win. Their standard is they have to be able, ethically, can they prove this case beyond a reasonable doubt? So the Strickland test basically lays out the standard. And it's interesting because some of the case law over the years has developed where, if you don't file this appeal, even though the attorney says there's no appellate issues, and the defendant says, now, I wanted you to file that appeal. A Supreme Court case came out about 2 weeks ago that said that's ineffective. Even if there's an appellate waiver in the plea agreement, you think there's no legitimate appellate issues, you still now have to file an appeal for the defendant. Otherwise, you are ineffective assistance of counsel per se. And then on top of that, you have to show not only that the attorney was ineffective, but that it would have made a difference, that what he did or failed to do would, and the new evidence or the new strategy or new evidence, not only would it have just new, but it actually would have resulted in a different result. So it's very difficult to actually get over that hurdle. It happens quite a bit. It happens usually where the attorney gets on a very serious case and they don't have the resources to adequately prepare and defend for that particular case. So back to the Syed case, that is the type of case where he could be tied up in the appellate courts for many years to come. So as I said, Mr. Syed, although he was granted a new trial, the appellate court said no. So then he gets to appeal to the state Supreme Court, and that court may decide that the lower appellate courts were incorrect if they choose to take the case. Not everybody has a right to a standard of review at the state Supreme Court. Then the next option is then you have to go file the habeas petition. Very complicated. Like I said, you have to exhaust all those remedies. So you have to say, I've been through my appeal. I've exhausted all my post-conviction relief matters. And then you have to convince a United States District Court judge, really kind of once again, that there's new evidence, that the other attorney was ineffective, and it would have resulted in a different outcome. Not just because there's, like Mr. Syed is the cause celeb, during this particular time, but you have to look at the actual legal standards. And the ironic thing is then once, if you lose the habeas matter in the U.S. District Court, then you go to the appellate courts, the circuit courts, and then ultimately, potentially to the United States Supreme Court. And if the Supreme Court does not grant what they call writ of certiorari to the Supreme Court, then you really go back and then you say your post-conviction, your counsel at the district court level was ineffective. And they kind of start all over again, and you keep going through that. And so as you can see why it takes 10, 20, 30 years for somebody sentenced really to be ultimately final, and particularly in death penalty type cases, why it takes so many years if someone is actually sentenced to death to get there, because there's all of those different levels. And once they get to the top of the level, I think it's the end of the line, they try to come up with new issues once again to try and say that somebody was ineffective. It's that kind of, it just goes on and on and on. So Mr. Syed will have to do that. Bringing that back to Christopher Watts, he's pled guilty. Now, he's only, 6-7 months into his sentence. He has confessed, not only by his plea, but by his interview to the detectives, and then his follow-up interview that was done with the FBI, Colorado Bureau of Investigation, and the Frederick Police Department up at his new home up in Wisconsin. But over the next 20 years or so, Mr. Watts, and I use the term loosely when I say Mr., so I don't need a lot of commentary of why did you say Mr. Chris Watts, he will, could potentially say, you know what, boy, I really don't like it here. I wasn't really thinking straight. My attorneys pressured me. I should do this. And literally, he could start a post-conviction relief. Now, most cases, there's kind of you have a short window in which to do that. Usually, it's the same period of the statute of limitations of the offense in which it was done. So if it's, say, 3 years or 5 year statute of limitations, that is what you have to do. You have to file that post-conviction relief in that time period once the judgment of conviction is final, which is after the appellate decision. But on a murder case, there is no statute of limitations. So Chris Watts, if he wanted to do something along those lines, could do it 5 years, 10 years, 20 years from now and try to say that there was something there. Or he could say, you know what, I lied to everybody, and over the years, I'm just a big fat liar. I lied to my defense attorneys, I lied to the court, I lied to the cops, I didn't do it. He could actually do that. Now, who knows what kind of play he could get. He could, there could be new technology, who knows what was actually saved. As you see in the discovery that we have posted at ScottReisch.com, that items were collected and tested for discovery, but none of those lab results actually came back. And once again, even if his DNA is there, you'd expect it to be there. It's his house, so that's not a big deal. Anything around the children, remember, if some of you may recall that his defense attorneys wanted to be there for the autopsies so that they could try to see if there was any DNA around their necks. My guess is that none was actually recovered, given the fact that they were covered in oil, crude oil, because they were stuffed in that tank battery with crude oil in it, and it just helped to advance the decomposition process. So it's very unlikely that anything like that could actually happen. So that's where what they call post-conviction relief. So Mr. Syed, the case in Maryland, that's what he could try to do. That's what he's going to do. That's what he's been trying to do for the last 20 years. And it'll be interesting to see if he gets that. The DNA is an amazing technology that's developed. When it first came out, I was a kind of young lawyer, didn't really understand it, but we hired a lot of experts for it. And it's come to these days where it's literally just accepted. The thing that you have to really watch for these days are the statistical analysis that takes place. Because it's all the statistical analysis when they say the odds of it being someone other than the defendant, when they take it from a known sample and they say, oh, it's 1 in 650 quadrillion, and they say there's 10 zeros or whatever behind that. Then you have to look at the actual, how they came to it. What was the size of the population in their database that they compared it to? Because if the database comes back and you say, well, this is only, the small database, and really it comes down to it's 1 in 4 people could have had the similar type of DNA, that reduces the chances. So the DNA labs these days always try to make these huge numbers to say it's basically impossible that it should have been someone else's DNA. And we've also done a video on that where we talk about DNA, where we explained STR and YSTR type DNA and how it's used and how it can be used to break down mixtures, and when we can also figure out multiple males if they're in the DNA sample as well. So that's that. So let's kind of recap here. Can't believe how quickly time goes by when you're chatting like this. But what it's, so once again, my name is Scott Reisch. This is Crime Talk. Thanks for tuning in. We're obviously going live this evening. And we put a post up on our community page on YouTube to one, let people know today that All the paper discovery, all the police reports are on that website, so you can take a look at that and read them at your pleasure. A lot of people, heard a lot what was said, heard what other people said, but I always find the best source is to actually try and go read it yourself and be your own judge and, make your own conclusions about it. Don't ever just trust everybody and their opinion, because not everybody knows all the answers, particularly in a case like the Watts case, where you just simply don't know all the answers. I mean, I don't think that we will ever actually know. Now, the one issue that keeps coming up, and it's clear that a lot of people do not like Nicole Kessinger, and that's simply because, she was the mistress of Chris Watts. Some of her statements that she made to the police simply do not add up as it relates to the emails that are in the discovery that you can find at ScottReisch.com, as well as her text messages, where she says, "Oh, I didn't really know. I tried to keep my space." But then you can see in her web searches that she was clearly looking for wedding dresses, book deals, those types of things, but really make her look like she doesn't have the most clear conscience. It also shows that early on that she knew that Chris Watts was married, and she pursued it, and she ultimately said that she basically wanted that life, that of Shanann, where the house and the burbs, the 2-3 car garage, little picket fence, 2.5 kids and a dog. And so it really, calls into questions her motivations. And it really makes people wonder, and we're not saying that she's done anything wrong. There's a presumption of innocence, and we're trying not to get sued. So, but it's very clear that she had an influence. I think that can be reasonably inferred from the evidence that is there, that Chris Watts was persuaded, wanted to be with Nicole Kessinger, and who put these ideas in his head? I don't know. It's just, we may never ever know unless somebody says something. For example, if Chris Watts actually says something, if Nicole Kessinger says something, perhaps to a friend. Oftentimes you will hear of situations whereby cold cases, they go unsolved for years, decades, and somebody says something at a bar. They maybe disclose something to their wife, their lover, a little pillow talk at night, and then something comes out. And so it's that's how cases are solved. I did a case, 4 years ago now, I guess it was. It was a cold case, some multiple homicide, sexual assault type case, and they had talked to people, but they went back in their investigation some 20 years later and re-interviewed people. And guess what? Somebody said something, and it just rekindled the investigation. So you just never know when it comes to cases like this, like a homicide. Someone will always have their ears on, so to speak, and they will be listening. And then you have to wait and see what comes about. Because a lot of people, it's no secret, there's a lot of people out there that thinks that Miss Kessinger, whether she was there, whether she was down the street, whether she was providing moral support, encouragement, something along those lines, it just really, a lot of people have questions about her potential involvement in that case. There's nothing to say that there's anything that would warrant probable cause whereby she could be arrested. And then the other issue that comes about is when the police officers and the FBI went up to see Chris Watts recently, about a month ago or so, was that some of their reason? He talks on those interviews where he wonders if Nicole Kessinger is writing him, perhaps in a pen name, a pseudonym name, to him. He's obviously getting mail. And if you go and you look at ScottReisch.com, some of the discovery are letters from females in there that are basically saying, hey, we're part of the Chris Watts fan club. We believe you, and whatever we can do to help you let us know. Who knows? Maybe one of these ladies will have financial resources and convince him that one day he too should, want to be with her, and the only way to get out is maybe file a post-conviction claim to do that. You just never, ever know. And then, like I said, who knows what this guy is saying is the truth. It's obvious that when he was giving his interview and the police asked him, well, is it possible that Shanann did something to the children? He grasped onto that. And he admits as such in that interview with the FBI that he said that it never crossed his mind until they brought it up. And so the whole issue of, is this really what happened, or is this just something that he's saying? Is his interview today or a month ago simply trying to make himself look better? Is it simply trying to make others not look as bad? Is it trying to seek sympathy? Is it trying to reconcile with his parents? There's conversations in there whereby Shanann's parents say that he is, that they love him and they've forgiven him and all that type of stuff. And he's like, wow, I'm shocked and surprised by that. So you just never know what this guy is saying is the truth, or whether he's just, telling the story for the audience of that particular day. We may never know. And, we'll have to also see what happens if and when Chris Watts gets to general population. If something's going to happen to him, if he's going to tell a story to one of his cellmates and maybe says perhaps there was someone else involved, someone else helped him plan it, assist him in any way, that cellmate would get himself what we refer to in the criminal defense world as the golden ticket. If someone had information like that to say, hey, this is what he told me, and they go check it out and they can kind of corroborate it, that may be enough. But even then, it may be enough for somebody to potentially be charged if somebody close to him learned something from Chris Watts while in custody. And yes, that person would be characterized as a jailhouse snitch. I'm sure he would want some benefit in exchange for that, but that's what people do all the time. One of the reasons why, as a defense attorney, you want your client to keep his mouth shut. One is so the police don't know the facts of the case. But second of all, it's if they do know something, they need to get something in exchange for it. Some people may not like that. It may sound kind of icky, so to speak, but that's the way things work. I've had cases where jailhouse snitches have come forward. I've represented people that have been jailhouse snitches. And guess what? If that information checks out and looks legitimate, my client wants something in exchange for it, a reduced sentence, a deal on something that is maybe on his case, maybe a new trial, reduced sentence is usually what you ask for. Or sometimes it's just simply, hey, I want to go somewhere where my quality of life in prison can be better. Move me out of state. I don't want to be at this particular facility because it sucks. There are no programs that somebody can get into. It just depends. So this case is far from over. It will go on for years, in my opinion, if not decades. The big question is where is Nicole Kessinger? The Adan, thank you for the super chat. Where is Nicole? Good question. I have done some quick searches to see if we couldn't find her. But now I think we're at the point, and I've had more time now, where I will have one of my private investigators try to track her down. And some people will say, why would we want to do that? Should you do that? There's been all this speculation that somehow Nicole Kessinger was in witness protection or something along those lines, okay? And quote, witness protection can take several forms of that, okay? Witness protection can literally mean we're going to relocate, the government, the prosecutors, will relocate somebody to a new city, a new town, and basically you have to cut ties with everybody in your family because they truly believe somebody's life is in danger. And in that particular case, okay, fine. But guess what? You can usually find them. I had a homicide case years ago. Witnesses were in witness protection. Everyone was relocated to a new city. And guess what? My investigator ran a comprehensive search on them and a cell phone popped up. So what do? We jumped in the plane, we flew down there, knocked on their door, and guess what? We spent about 2 hours talking with them. We even had dinner with them, told us all kinds of good stuff. And so anyone can be found. And when someone is in witness protection, like I said, it could just be a few bucks to relocate, go out of town, go find a new job, but basically you're on your own. The more serious stuff is what you hear about with like the feds when you have a crime boss or something along those lines where their safety is truly in jeopardy and they have to literally go relocate. But even then, people can be found. They can be found all the time. So, Ms. Kessinger, I saw one of the things, comments go by that somebody said Nicole Kessinger was skiing in Vail a couple of weeks ago. I have no information to prove that at all. I have nothing that can corroborate that. But hey, you know what? Who knows? It's like a lot of my clients, when they fail to appear, they are literally, they're usually within a 10-block radius of their house. Why? Because they have nowhere else to go. She may have the same situation. I'm sure if you find her dad, I'm sure she's going to be close by because who gets to take their father to a police interrogation? I've never seen that before, okay? Unbelievable to me. One of the reasons why police talk to people individually is they don't want them to have that support group, somebody interfering with them. Police don't even like when attorneys show up to an agreed upon statement or proffer agreement because they want to have the person talk and not have the attorneys there sitting, whoa, this isn't covered. If we're giving you that information, we want to receive more benefit for that as well. So, quick recap. My name is ScottReisch. I am a criminal defense attorney here in Denver. Started this channel, 6-7 months ago, kind of when things really took off with the Chris Watts case. And the reason why I did it was because it was so frustrating because you see something on the news and these people covering the court appearances have no idea what the hell they're talking about. And it's just pure speculation and they just stay stuff. And like I said, it's so frustrating. You see what's on the news versus what happened in court, whether it was my case or another case, that's not exactly what's said. And they don't know the difference between a preliminary hearing and an arraignment, but yet they act like it's the word. And then people repeat that and it's just simply not correct. And even as an attorney, we have to be very careful as to what we state about a case that's pending before the court because we can't just, make stuff up. I know a lot of people think, attorneys are liars. Not the case at all. We are ethically prohibited from lying to the court. yes, you can absolutely say your client is not guilty, because he is. Unless and until he's convicted, he is given the presumption of innocence, all right? And even in court, you can, even if the client is, there's overwhelming guilt, the attorney can still get up and say he's not guilty. The prosecution has failed to prove their case beyond a reasonable doubt. And the thing is that the defense can argue the reasonable inferences drawn from the evidence or the lack thereof. And so, that's why people think, oh, defense attorneys lie, defense attorneys aren't being truthful. No, that's not the case at all. They are arguing the reasonable inferences or lack thereof from the evidence that's been presented or not been presented. And people don't like that. But like I said, I've said this before, this is not a technicality. This is a constitutional right. This is people's constitution. There's no technicality. There's nothing where people just get off easy, so to speak, because it didn't happen. If somebody's found not guilty, don't blame the defense attorney. Go blame the prosecutor. They're the ones that present the case. And if they failed to prove their case, then it all rests on them. But people want to blame the defense. Why? Because they were there with the guy that was the bad guy, so to speak. So, you have to keep that in mind, because everybody hates defense attorneys until they need one. And I assure you, ladies and gentlemen, in your lifetime, whether you or a family member or a friend will somehow get in trouble. It could be something simple as a DUI, or it could be something more serious. Your kid goes off to college and gets accused of sexual assault, or gets involved in something that he doesn't really appreciate the seriousness of it, and they get in trouble. And then they call people like ScottReisch. People call defense attorneys, and that's what they're supposed to do. What was Scott drinking? Scott's drinking water. What is he drinking from? He's drinking from his Kentucky Derby glass that he got several years ago, that when he went there and watched the Kentucky Derby. It was fabulous. Yeah. And rumor has it, maybe there again this year. So love Kentucky, love the Kentucky Derby. And frankly, I do look pretty dapper in that seersucker suit and bow tie, not gonna lie. But we shall wait and see if it all comes to fruition. But you never know. All right, so once again, if you like the channel, please subscribe. I appreciate what everybody has done to help make this channel grow. We try to provide good content, and as I have stated previously, I've been out of kind of pocket, so to speak. I was doing a double homicide case in a small town in the western slope of Colorado, and that was a 3-week trial, and it sort of took a lot out of me. One, I was out of the office for 3 weeks, and if I see a seersucker suit, I am unsubscribing. All right. And then just try to get back into everything as well. It's just been super busy and tough, but we are trying to get back into it. Had some production issues back and forth, just schedule-wise. It was tough. And I know people have sent me links, whether it be in the comments, as to other cases that they would like to have covered. Please let me know. Please do that. If you have a really good case, even if you have some inside information on the case, you can send that to me via an email at scott@scottreisch.com, and we will try to do that as well, and try to provide interesting cases. I know a lot of people in this that watch this kind of particular genre of crime, true crime type of information are truly obsessed by it. because frankly, it's interesting. Some days I think, oh, I want to go do something else. I want to go, I don't know, make sub sandwiches or work at Starbucks, because it can get very exhausting dealing with defendants, families, district attorneys, judges. That kind of stuff is, it can be super exhausting. But it is interesting in this type of stuff, because most people don't get to deal with it. There are so many things that are unknown, and so it's I understand why people are interested by it. Some people are shocked, offended by what I do for a living, but they're always the same people that still, when you go to cocktail parties or wherever, want to ask, so what was your day like? Tell me what you've done. Tell me a story that we wouldn't be able to believe. And it's there are some crazy stories, and literally every day I think to myself, you cannot make this stuff up, okay? Let me just give you an example of this. True story, not revealing any names, so I'm not doing anything unethical in any way. But I had a client that he was previously convicted of a sexual offense. He's a younger gentleman. He then meets an older woman who is in the process of a divorce, but they like each other. She has children. The couple gets together, and the daughter alleges that the new boyfriend, the previous sex offender, had touched her inappropriately. So the dad then goes to the mother's house and is outraged and upset and cannot believe that that in fact had taken place. How could you allow that? You're a terrible mother. And he ultimately shoots her in front of the family. He's charged with murder, not my client. My client is charged with the alleged sexual assault. Client maintains his innocence. We are actually set for trial. And the beautiful thing about the adversarial system that we have in our court system, whereby they just don't go on endless investigations on the prosecution. In some countries, the prosecutor presents the case. We have this adversarial system. Someone presents a fact, the defense can say, no, that's not true, let me correct that fact, or it didn't quite happen this particular way. And so we're getting ready to go to trial, and ultimately we have a hearing, and this young lady ultimately admits that she completely fabricated the allegations against my client. So the cases get dismissed. Well, dad, who's sitting in custody, finds out and learns what had taken place, what had transpired in court, and that the case was going to be dismissed, and his daughter was less than truthful on that matter. And he ultimately kills himself, hangs himself in the jail. Now, crazy, right? You can't make that stuff up. I wouldn't have thought to come up with that scenario ever, but it was true, okay? And that's what I do love about my job, okay, is that I never know what's going to happen on any day. So that's what I love about it. What I hate about my job some days is I never know what's going to happen. I've had days where I thought, I'm going to be in the office all day, and I get to work on a case. I get to actually do some office work and sit down and do lawyer stuff, so to speak. And then I get a call saying someone was just arrested, or somebody's at the front door and they have, someone has been charged with a crime. So I get to go leave and go to the jail, contact police. And it's that kind of situation where you just never know what you're going to be doing. Most of the time you get your work done is on the evenings and weekends. And so if anyone ever thinks that you're going to be a defense attorney and you're going to work an 8 to 5 type of job, you are sadly mistaken. And there's a lot of burnout when it comes to defense attorneys. And unfortunately, there's also a lot of suicides when it comes to attorneys because people take their job so seriously, they feel they've let their clients down, they feel like the whole weight of the world is on their shoulders. Also, a lot of alcoholism when it comes to defense attorneys, attorneys in general. And I'm not making this up. You can go look. You can go and see that the alcoholism rate amongst attorneys is actually quite high because it's a stressful job. People go home and say, "Oh, I'm going to have one drink tonight." Oh, it was a really stressful day. I'll have 2 drinks and 3 drinks, and then the 3 becomes the norm. And I've had many a friend over the years who has lost their license, lost their career, lost it all because of that. It's a very stressful job. And so when you see somebody that's done criminal defense like myself for nearly 25 years, it's really kind of the exception to the rule. You see a lot of people that just, they burn out 5, 6, 7 years. They're just like, man, this is not for me. I can't do it. It's too stressful. My kids grew up with the knowing the difference between county jail and prison. There's a difference. County jail is where you go to misdemeanors or where you're waiting before your trial goes on. And then you have the prison side where you've actually been sentenced for a felony. And so that's kind of a weird thing. You think, wow, your kids at a young age know all that stuff. And then on top of that, even when you're home, sometimes you're not home. You just want to veg and watch mindless, numbless TV, and you can't always be the best partner, so to speak, because you're too exhausted, and you just simply can't. You just can't take your mind off of it. Even though you try to turn it off on the drive home, it's hard to do. You can be sitting in a movie theater and suddenly you're thinking about a case, because how do you just turn it off? It's not like you're making widgets and you set the widget maker down at the end of the day and go home. And the other thing is you give up a lot of family time. I've canceled many a vacation. My kids will probably confirm that. Missed many a vacation. Wasn't able to make certain things, although I did a pretty good job of it, trying to get to everything when they were younger growing up. But stuff comes up. You get held up in court. The judge sets something on a date and he's like, no, this is the date we're doing it. You need to be here. And you say, well, Judge, I have a vacation plan, or I have a CLE that I'm going to. And then you simply, you have to change that because that's what the court says you're going to do. Particularly when I was younger and we were a solo practitioner, it was very hard to do that. Now, I have 4 other attorneys in my firm, so we can make those things work. And over the last couple of years, I've taken more vacation time than I have in the last, probably 20 years. And so it's it can be that. And it can be pretty devastating as well. I remember once, one of my children asked me if basically, if I cared more about my clients than I cared about them, because it felt like, if the call came in, I had to take it. If I had to run off to the jail and didn't get to tuck them in bed at night, I wasn't there for them. So it makes you think maybe I was a terrible father and things at that time as well. So, while we're talking, or as somebody said, was this therapy for Scott? No, I'm just telling you kind of the way it is. Everybody sees what lawyers do on TV or, whatever show. It used to be LA Law, like when I went to law school, it was LA Law, and everybody, went to work and everything was resolved and didn't work late hours, etc. And everything always got resolved. It's just simply not like that. And I think law schools these days need to be more realistic with these law students when they go in and, they go in $250,000, $300,000 or more for a law degree. and everybody thinks you're going to be making 150, $200,000 out of the gate. That is simply not true. And because frankly, there's a lot of attorneys out there, and a lot of people that go to law school don't practice law. I knew friends in law school that got to their second or third year and said, you know what, this is not what I want to do. And so it's, you have to be certain this is what you want to do. Saw one of the comments come up. Let's see, I believe Mr. Reisch is married to a judge. No, I'm not. One of the comments that went by is the parents that helped get their kids into school by falsifying information, saying that they were part of a, going to be in a sports team, or basically helping them take tests and things like that. Like, you got to be kidding me. You should be able to give your children the tools that you need to make them a better person. But if you have to, basically go, have somebody take the test for your kid, falsify their resume or something along those lines, that kid doesn't deserve it, okay? That kid deserves to fail. But that goes along with all the butterfly, and what do they call them now? Snow plow parents, where they move all the obstacles out of the way. And I tried to give my kids every advantage they could, but that meant, oh, you're not doing well at a particular class? Let me get you a tutor, because maybe your teacher's not explaining it well. Maybe there's not enough time. Maybe you're a high-rep learner, and you need to have it explained to you 10 times versus the 5 that the teacher's going to be able to give you. And so, that's the how I feel about that particular case. These people, these movie stars, they're going to get a felony more than likely. They're probably going to go to prison. And I don't think these people realize that. When you go to federal court and you are charged on a federal indictment, very, very rarely are you going to get probation. It simply does not happen that often, because the sentencing for federal cases are just super high. You're in the big time, so to speak, at that point. And they probably have a pretty decent case against you. So, these people, they have all the money, they have all the resources, these actors that are, paying large sums of money to get their kids in. That's just BS. So, they're gonna punish for it, and these kids that they think they can just have everything from privilege, it just doesn't work that way. They need to go out and work for it just like anybody else. All right, let's see some of the other comments here. The Smollett case, that's another case I wanted to talk about, because the Jussie Smollett case is interesting, and I had some real interesting comments after talking about that the other day, because people said, oh, you must be some sort of Trump supporter, this or that, because the people related to the case were had a relationship with Smollett and people that worked for the Obamas. That's come out. It's true. The Department of Justice, the U.S. Attorney's Office is there. They're looking at that. They're going to investigate that. It's going to be, I think, rather revealing when that information comes out, because that type of deal doesn't happen, okay? And the explanation that the district attorney, the state's attorney, gave, she lied. She was not being truthful. And the National District Attorneys Association and the Illinois Prosecutors Bar Association, and the Illinois Prosecutor Bar Association has nearly 1,000 prosecutors in the state of Illinois that are a part of this. And if the office recuses themselves, the whole office goes away. Okay? I have a case right now pending where the DA office recuses themselves. They say we're off. They have no involvement in it whatsoever. They just don't pass it off to some lower deputy and they say handle it, but we don't want to know. We're just going to, what they refer to as a Chinese wall. We're just going to not be involved in it whatsoever. Not happening. The special prosecutor has to be from a separate office. And so when Miss Fox, the state's attorney there in Cook County, said that she recused herself, that's total BS. And the prosecutors in the state of Illinois called her out. And they put in their statement that said, when an elected state's attorney recuses herself from a prosecution, Illinois law provides that the court shall, not maybe, shall. It's mandatory. Appoint a special prosecutor, and then they give the applicable section of the Illinois Code. Typically, the special prosecutor is a neighboring state's attorney, the attorney general, or the state appellate prosecutor. Here, the Cook County state's attorney kept the case within her office and never actually recused herself. So, she's not being truthful and candid on that. Maybe it's because she's just a political hack that was elected and has no real experience, or maybe she did it because she thought that everybody is just too stupid to realize what's taking place. You would think that she would know what the rules are. But like a lot of politicians out there, they think that everyone is too stupid and they don't need to know, and they're not enlightened enough about something, and so they're just going to lie to them point blank to their face, and that's what she did. And so where she says the state's county that it wasn't mandatory as it relates also to the sealing, that is not that it was a mandatory sealing, that it had to take place. Her own colleagues from the Illinois District Attorneys, the Illinois Prosecuting Bar Association, says that is inaccurate. And so they called her out on two lies there, because she obviously thinks that everybody is too stupid to do that, to figure it out, and that nobody cares, and no one will question it in any way. And then they go on and further criticize her that the appearance of impropriety here is compounded by the fact that the case was not on the regular scheduled court docket when it was supposed to be, so that the public, the press, could actually be there and take part of it. But they did it, once again, trying to sneak it through, thinking that, once again, no one's going to notice and that everything is going to be swept under the rug. There's nothing here, move along, etc. And so that's just ridiculous. And when her own bar association and the National District Attorneys Association calls her out and says you're a liar, this woman has some serious credibility issues. And I don't know why the constituents in Cook County are not asking for her resignation. I have a friend I spoke with just the other day in court. He came from the public defender's office in Illinois. And I asked him, like, hey, man, where do I get one of those Smolletts for my client? I said, have you ever had a case where a client has 16 felony counts and you get a deferred prosecution and a dismissal all on the same day? No. It stinks. It's just sucks. And then the National District Attorneys Council, they actually have recommendations and protocol for when it is a high-profile case. And basically, it has to be above, there has to be transparency, and everything has to be done beyond reproach. So it doesn't look like it smells. It doesn't look like somebody's getting a deal. And this type of case absolutely throws into question the whole credibility of the judicial system, not only nationwide, but certainly in Cook County, because if you're connected, you can do that. There was actually an internal email from the Cook County's prosecutor's office where they were asking other courtroom deputies to say, hey, obviously this is blowing up in our face. We want more examples. We need examples of cases where similar deals have been offered. To date, nothing. They can't. Mark my word that is not going to happen, and this is simply it's a sham. It makes everyone look bad. And one of the fundamental things of our criminal justice system is equal justice. You know, Lady Justice, the little scales of justice, blindfolded. Justice is supposed to be equal to everyone. It doesn't care who your daddy was, how much money you have. You're going to be treated the same way if you are completely indigent and have not 2 nickels to rub together to your name, or whether you are a billionaire or a famous movie star. You're going to be treated the exact same way. And if that's not the case, and it's become this transparent that that's not what's taken place, it questions and calls into question the criminal justice system, not only in Cook County, where everybody always kind of, the rumors are that it's a little shady, but it throws into question the whole judicial system, because they were trying to help somebody out, give somebody a break. Well, they can't do that. And if district attorneys are going to make decisions based upon political questions, political decisions, then you know what? They need to go find a new job. Their job is to do justice, not to get convictions. Their job is not to cut deal for their friends. Their job is to do justice, treat everyone fairly. If they can't do it, then they need to go get a new job. This Miss Fox, she should resign as district attorney, in my opinion. I think that's really what she should do. But we will see what ultimately takes place. Now, the one last case that I want to talk about this evening is the case that is involving the Navy SEAL. And this Navy SEAL's name is Mr. Gallagher. All right. He is a special warfare operator a Navy chief, Edward Eddie Gallagher. All right. Now, he's on trial for war crimes that were allegedly committed over in the Middle East, whereby he's allegedly killed 2 people that he believed were, out to kill him. ISIS, bad guys, right? Apparently had a re-enlistment ceremony basically over their bodies. And then he's also charged with obstruction of justice, whereby he apparently tried to intimidate or tell other Navy personnel that they should not be Happy Fox. Thank you for that $20 super chat. Thank you. Very, very nice, but certainly not necessary, but it definitely highlights it here on my screen much better than the other ones. So Chief Gallagher is facing a court-martial. He's currently in confinement out at the Navy Brig in Miramar, California, and he is awaiting trial. Originally, the trial was supposed to be in February, but it got continued until May. Unsure exactly what the nature of the delay was. Usually in cases like this, it's witness issues. They have to bring their witnesses in from the Middle East to come and testify. And I'm not saying Chief Gallagher, what he did was correct. I don't know enough of the details. Obviously, the laws of war prevent people from doing things they shouldn't do. You're not going to kill innocent combatants. If people have surrendered, you cannot torture and kill them. What I do understand in this case is that he believed, the Chief Gallagher believed, that the individuals that were killed were going to try and kill them. And so that's the type of situation whereby he wound up killing these individuals. And so, something here is, and that's, and so ultimately he goes to trial. Now, the military system is a lot different than the court system that we all know, obviously in the state and the federal system, but I was a judge advocate in the Marine Corps, and so I have some little bit of knowledge on this, so I can speak with, I think, some authority. So what happens is charges are investigated. The investigating officer does their investigation. He presents his report to the commanding officer. It's going to be a general level officer because he's going to a general court-martial for felony type of charges here. And then Chief Gallagher is entitled to what they call an Article 32 hearing. And this is in front of a military judge. And the Article 32 hearing is similar to a preliminary hearing, but the military judge is the one that recommends what charges go forward. And he can say, yeah, there's some on this, and there's some on maybe not enough evidence on this, but we're going to go forward on that. And then obviously you have a trial. It's very different because it does not have to be a unanimous verdict in the military like you would expect in the civilian world. And that can cut both ways. Depending on the number of jurors you have, it has to be a 2/3 has to vote for conviction. And what takes place in that trial is once the evidence is presented, very similar, direct, cross-examination, defense doesn't have to do anything, presumption of innocence, all those types of things. But the jury is the interesting part. As an enlisted gentleman, he can ask for enlisted personnel of equal or higher grade on his panel. Otherwise, it will be all officers, but he can ask for enlisted personnel as well. And so when the jury gets the case, they deliberate and they talk about and discuss the information, and then they take a vote once they've said, all right, we've decided about it. And if there's not 2/3 to convict on that first vote, it's not guilty. If it's 2/3 or above, it's guilty. But what is more unusual, and you don't see this very often at all, is the sentencing portions of it. All right, but let me back up. And yes, I will start the dishwasher before I come up. But there's a defense. Okay, and we've talked about this in the civilian world. It's not whether you're a good person, you're a bad person. It doesn't really matter. It's simply whether the facts took place or not. But in the military, there is a defense of good military character because it's recognized in the military that if you are a good soldier, good sailor, that you have good military character. Maybe you made one mistake that you basically deserve a pass, all right? And we used to run this defense all the time. Where I was stationed, we had what we refer to as water walker Marines. They were good. They were the best of the best. And every now and then they would get in trouble. But you could bring in witnesses who could testify as to their good military character, which is basically, if I was in a fighting hole with somebody, would I want this guy next to me? And that in jury instruction would say, you have heard evidence of good military character. You may consider this, you may reject it. But if you find that someone has good military character, that in and of itself is enough to raise reasonable doubt. Okay? So Chief Gallagher, who has been on deployment not once, okay, and understand he's a Navy SEAL, so he's already a water walker, okay? He is, by definition, someone that has good military character. He's smart. He's loyal to his country. He's loyal to his command. He has sacrificed for his country. He's sacrificed for his family. And he has been to the Middle East not once on deployment, where people are trying to kill him, not twice, not 3 times, not 4 times, not 5 times, 8 deployments where people were trying to kill him. All right? I would say that someone that's been there 8 times probably has a second instinct of who is trying to kill you and who is not. And if he killed those individuals, he may have a pretty good shot of saying what I did was reasonable, what I said was justified. And even if the jury were to find what you did was wrong, it was against the law, but we're going to say not guilty simply for the fact that he has good military character, okay? And so let's say Chief Gallagher is actually convicted. He can then submit, even before it goes up on appeal, a clemency package, but guess what? It goes to the same admiral in this particular situation who decided to bring a court-martial against him. So my experience, those kind of clemency packages do not work. And then if he's ultimately sentenced, usually he'll be sentenced to Leavenworth to serve out any type of lengthy sentence, if that is imposed. And then he'll have appeals that go to the Court of Appeals for the Armed Forces and ultimately to the Supreme Court if he exhausts those remedies. And ultimately, the president could pardon him, and that's kind of what brought this case back to the forefront. I've read about it a couple of times, but today the president was trying to make accommodations based upon several lawmakers who wanted Chief Gallagher moved to less restrictive confinement. Given his service, he's apparently also suffering from PTSD, and he is not getting the psychological treatment that he may need. So that's going to be an interesting case to watch here in the next couple of weeks. The president certainly has to be careful with what he says about this because there's a thing in the military called unlawful command influence, whereby if it is seen where the command is trying to basically interfere with and persuade somebody a particular way, usually it's when it's against the defendant, that the case could even ultimately be dismissed or sanctions be imposed, or a new convening authority, the person that brought the charges, could come back to a new CO, basically remove them from them. So, hey, I want to thank you very much for watching this evening. I appreciate you tuning in. I know it's late, but, simply when cases come up, sometimes it's just easier to do this at night and to do it live versus shooting it and editing it. It's just faster to kind of get it out there, and hopefully you'll enjoy it. I appreciate you watching this evening. I appreciate you making comments. Really appreciate any super chats that anybody could give as well. Not necessary, not asking for that, but it certainly does help highlight them on the questions that do roll by. Thank you for watching, and have a wonderful evening, and we will be turning off. Have a great night.